Mr Chair.
The Honourable Judith Collins.
Mr Chair, just to deal with a couple of the comments made this evening. In fact, actually the best commentary that I've heard on this matter from this bill from the Labour Party has not actually been made tonight, but it has been made by the Honourable Phil Goff in the second reading. And Mr Goff dealt with the issue of those aged over 65 and those who may wish to be excluded from jury service, or excused, I should say. Mr Goff said, and this is a quote, "The bill also allows people to seek exclusion from jury service on the basis of their disability or their ill health, or if they are over the age of 65. The important point here is that those who seek such an exclusion are excluded permanently from service." And he said that he felt it was an important point that this does not, this is a quote, does not introduce an age limit for jury service, end of quote. He then goes on to talk about how, I think on that basis, that is, that people can choose themselves to be excluded, Mr Goff says, "I think on that basis the permanent exclusion provision is acceptable." Now that's the Honourable Phil Goff, second reading of this bill, and what has changed since then? That was the second reading of this bill, which was in fact the 22nd of May this year. So Mr Goff said that. Now he's a former Minister of Justice under the Labour government, and what we've heard tonight from the Labour Party is this is a dreadful provision, and that we're somehow penalising people aged over 65, or words to that effect, that we were patronising them, that we were saying that they were discriminating against them. We've heard that comment from them tonight. Now, just a few months ago, the Honourable Phil Goff, he'd read it. He'd read the bill. He understood the bill, and he wasn't taking a point just to be silly about it. The fact is, he did in fact, he looked at it and he felt that actually it was a fair provision. Since then, having consulted with the Green Party, they suggested we should look at whether or not someone who wanted to permanently excuse themselves from jury service on the basis that they were over the age of 65, that they might want to come back into jury service. We allowed that. We said that's a sensible amendment to make, because somebody might feel at some stage that they just couldn't cope with doing 3-week trials, that they may be 75, 80, something like that, and then they might get better, or they might decide that actually they can do it, they can put themselves forward, and then it's up to the people who choose the jury to decide whether or not they are selected. Well, actually, I thought that was a sensible contribution from the Honourable Phil Goff. I'm surprised that the Labour Party didn't read the words of their former leader and former Minister of Justice. They never listened much to him when he was the leader, but I thought his contribution was good. I thought it was sensible. It wasn't particularly political. He was looking at it, having looked at all of the ramifications, looking at how can people be fair in this, and I actually think it was a jolly good contribution, sadly not made tonight, except through me repeating him. We've also heard the comments about Mr Chauvel has commented about how, what was it he said that I said, oh, we couldn't do anything about these nasty murderers. Well, that's not actually what I said. I pointed out that the person who is a self-represented defendant in a criminal trial, for that person currently to get access to jurors' particulars, including addresses, this could be a very dangerous thing, and that is the evil that we're trying to remedy. However, even that person, the accused, has still got the right to a fair trial. And so the provision in the bill is that, in fact, a lawyer will be appointed for the purpose of enabling that defendant to be able to know who is on the jury, but not to take that information away. And if the lawyer, Mr Chauvel, not the defendant, if the lawyer provides the information to the defendant or breaches the trust that the court has placed in them, then that lawyer would be up for contempt of court. Now, that is a serious offence for a lawyer, as Mr Chauvel knows. However, the defendant who is up on a trial on a charge of murder, for instance, is hardly going to be concerned about that. So I think what it is that it's important to understand we need a provision in there to enable the defendant to get a fair trial, to know who was on that jury. It could be someone who has a long-standing angst against the defendant, may have a long-standing angst against them, but unable to have a provision to say they can get the information they need, but not information they don't need. I think this is a very sensible provision. I'm very pleased that the House has been supportive of it in general.
The Honourable Leanne Dalzell.
It was not particularly instructive in relation to the